Well, as many of us noted, Auntie Bev seemed a whole lot more rattled than just finding out the defence was up to some secret attorney business. So I decided to have a look into things. Of course, we know the writ of habeas corpus has been lodged with the federal court system, which is a 700-page document that I'm sure we can all do without reading. Rest assured, everything that's in that document we basically heard at the SJC hearing. And while some lawyers may think, because obviously they're lawyers and I'm not, that federal habeas petitions are fairly common for state trial judges, what is not common is the trial judge presiding over their own recusal motion and promptly denying it, sitting on the bench bar committee, meaning she fully understands evidentiary standards including chain of custody, yet continues to ignore these standards and continues to allow evidence to be submitted despite its failure to meet evidentiary standards. Her continuing pattern of ignoring, overlooking and ruling in favour of law enforcement interests despite clear due process violations, i.e. Brady, and an overarching federal investigation into the DA's office and key witnesses. I very much doubt that all these compounding issues have been involved in previous federal habeas petitions before, making it pretty uncommon, to say the least. So how do all these compounding issues relate to how shook Bev was when she cancelled the hearing the other day? So that's what we're going to do today. We're going to do a deep dive into all the possibilities, not the probabilities, and there is a distinct difference. So let's start with Auntie Bev threatening the defence before she prematurely wrapped up the hearing. In the case where there's a habeas petition before the federal court, this could actually be considered a strike against her, not the defence. It could be seen as a threat of retribution. So let's start there with the possible potential reasons for her threatening the defence. The most obvious being shifting the blame from herself and the prosecution to the defence. But she could also be hinting that this habeas filing could profoundly affect the defence as an attempt to intimidate them into backing off. She may well be just striking out because she doesn't like the defence team going over their heads by seeking federal relief, or that they're simply strategically undermining her authority, which is a big no-no in Auntie Bev's court. Another possibility, as we have all suspected, is that she's looking for an excuse to hold the defence in contempt. She may well use Hank's allegations to justify holding defence counsel in contempt, which would allow her to penalise the defence without directly addressing the habeas petition. Another possibility is that she could be trying to disrupt the defence's strategy. She could claim that filing the habeas creates some type of conflict of interest, thus giving her an excuse to remove the defence counsel or revoke somebody's pro hac vice. But if she continues on this path of suggesting retaliation or intimidation, she could be forming the basis for a federal intervention request. Because under federal habeas filings, judicial intimidation is very much frowned upon. If the judge is acting out of anger and trying to suppress the defence's rights, it could be presented as further evidence that this court is not providing a fair forum. Federal courts can issue protective orders if they believe state judges are acting improperly. And if the federal court finds judicial statements on the record troubling, for example threats or coercion, this could increase scrutiny of their rulings. Whichever the case may be, Auntie Bev's abrupt shutdown of the hearing and veiled threats against the defence strongly suggest she was angered by the federal habeas petition, because it could lead to her losing control of the case, as the federal courts have jurisdiction to do exactly that when they find judicial impropriety. So this could be one reason for her outburst of anger. She probably expected that the SJC ruling was the end of the matter, but learning about the habeas petition puts a whole new pressure on her, because there's already a federal investigation involved with this case. and she's now going to have to tread way more carefully lest her judicial decisions intersect with the habeas petition. What happens when they intersect, I hear you ask? First, let's talk about what an intersection is in relation to this specific case and the habeas petition. We know that the habeas petition is concerned with the double jeopardy clause of the Fifth Amendment. In that petition, the defence must show that the state court's decision was contrary to or an unreasonable application of clearly established federal law, i.e. Brady violations, lack of due process, and of course double jeopardy are all examples. Or said simply, fundamentally unfair procedures. So each time the judge transgresses the defendant's rights that are constitutionally protected under a fair trial, along with double jeopardy, she's increasing the compounding list of issues that can be taken up with the federal court, so long as they are related to the Fifth Amendment and the right to a fair trial, i.e. the core issues in the habeas petition. One such intersection might be proceeding with a second trial before the habeas petition has reached its resolution, because the habeas petition specifically challenges a prior ruling that affects the fairness of the first trial, and so proceeding with a second trial could be premature and unjust. If the federal court ultimately overturns the ruling regarding the jury polling, it could invalidate part of the first trial's outcome, affecting how the second trial should proceed. It's not a hard and fast rule that Auntie Bev has to stay the proceedings until the habeas corpus petition is resolved. There are, however, precedents that suggest courts should stay proceedings pending habeas review. But of course, just because many Massachusetts courts do so to avoid unnecessary litigation, wasteful judicial resources, and potential double jeopardy issues, doesn't mean Auntie Bev's gonna. Fortunately, under USC 28, section 2251, federal courts have the authority to stay state proceedings when a habeas petition raises a substantial constitutional issue. Massachusetts state courts have long since recognised that proceeding with a second trial while an appeal or habeas petition is unresolved can create more unfairness. So on top of the refusal to recall the jury, depriving the defendant of a fair trial, the state court would be compounding that deprivation of rights by continuing with a second trial prior to resolving the petition. Now, the reason this didn't bother Auntie Bev while we were waiting for the SJC decision is because the state statute says that they must issue a decision within 130 days of the oral argument. So she knew that it would be handed down before March. But this petition is federal. In the hierarchy of the judicial system, the federal courts trump the state courts, pardon the pun. So essentially her hands are pretty much tied, and anything she does from this point forward that violates due process is under federal scrutiny, not her buddies at the SJC. But wait, there's more. If the habeas petition demonstrates that the jury acquitted on 2 charges, retrying the defendant on related or overlapping charges raises another double jeopardy issue and runs a very high risk of resulting in reversible errors. While the federal court typically avoids interfering with state cases, it does have exceptions where constitutional violations threaten fundamental rights. So, while the defendant could ask the federal court to stay the trial pending an outcome, it is technically possible for a federal court to issue a stay sua sponte, meaning on its own initiative, although highly unlikely unless the court specifically sees an urgent constitutional violation requiring immediate intervention. They may just set an emergency hearing to address whether a stay is warranted, or they could also issue an order directing the state court to respond, which could delay the trial indirectly. Either way, a stay is a potential possibility. And who knows, maybe the defence has already done it and put it under seal, meaning it won't even be listed on the federal court website. Now that would tear a fork in Auntie Bev's nightgown. And all these things I just described here may well be the reason she didn't want to address it in open court. Nonetheless, the way she responded definitely left her open to raising judicial intimidation in the federal habeas filing. As if she didn't have enough to worry about with the federal investigation, which could have serious implications for Auntie Bev, particularly if it intersects with her judicial decisions, prior knowledge of misconduct, i.e. that dismissal motion that she denied just before the last trial, or her potential connections to D.A. Morrissey, etc. These were all already potential threats to her credibility and to the integrity of the case. If the feds find misconduct with the prosecution, those findings could also scrutinise judicial handling of cases tainted by that misconduct. So if Auntie Bev has knowingly overlooked or enabled prosecutorial or police misconduct, it raises the possibility that her decisions could be examined for bias, favouritism, or ethical violations. If it even looks like that she had prior knowledge of police wrongdoing but failed to act, she herself could be facing legal consequences. Like, for example, when she said this to Ms. Little in court.
The Commonwealth cannot skirt their discovery obligations by simply failing to memorialize evidence that doesn't help them.
So does the Commonwealth have an obligation to create a document if that's not already in existence?
While technically accurate, it's a very good example of a concerning level of indifference towards the prosecution's failure to maintain a proper chain of custody. The fact that the judge acknowledges that no chain of custody ever existed, but does not appear troubled by this, that could be seen as a willingness to overlook serious due process violations. By admitting that no chain of custody exists, the judge is acknowledging a fundamental evidentiary failure, which under any normal court of law would cause the evidence to be inadmissible. Instead of questioning how the prosecution intends to proceed with tainted evidence, the judge shifts the focus to the defence's arguments, which deflects from the real issue, the prosecution's obligation to prove authenticity. Additionally, she fails to recognise that chain of custody is the prosecution's burden, not the defence. Under Massachusetts law and standard evidentiary rules, it's the prosecution's burden to establish a proper chain of custody before the evidence is admitted. Yet, Auntie Bev demonstrates a lack of concern over whether the prosecution can actually authenticate the evidence. To be honest, I would be very surprised if Trial 2 goes ahead without another attempt to recuse Judge Bev. I mean, the defence can demonstrate right now a pattern of unfair rulings, comments suggesting predisposition towards allowing tainted evidence, and a failure to enforce basic evidentiary rules. I mean, that's what I would do, but I'm not a lawyer. I'm sure the defence has a strategy. They are the dream team after all.